Well, with that, I'd like to welcome my colleague, Will Katz, who's hosting today's event, and we'll be introducing our guest speakers, Brent Gillette and Thomas Hertog, today that are with us. So take it away, Will.
Okay. Good afternoon. I would like to welcome everybody to today's webinar on starting and operating your own registered investment advisor business. Today, again, we are collaborating with Brent Gillette and Thomas Hertog from the Investment Law Group to make this presentation. Questions. We definitely encourage everyone to post questions during the webinar, but we do ask that you address all your questions to the panelists. This way all the panelists can see your questions. So here you have built a successful business as a broker in a broker-dealer or wirehouse environment, and now you want to become independent. Today, we're offering this webinar in response to this recent large-scale acceleration of advisors going to independent channels. Well, as we're seeing a lot of hedge fund managers moving to the advisor structure so they can run their hedge funds side by side with separately managed accounts. The reason we're seeing this migration can be contributed to the business model itself, as well as the financial crisis of 2008-2009. And that crisis really drove the demand for more transparency. The 2008-2009 crisis had a wide-ranging impact on the financial advisory business. These legacy Wall Street firms were, suffice to say, they were very humbled, and a lot of them nearly brought to their knees by a series of wide-ranging events. They had product failures and mismanagement. For many advisors looking to become an independent, RIA has always been a very attractive option. You know, as an independent business owner, you can control the type of practice you want to run, from the fees that you charge your clients, to the investment products you use, to any kind of additional services you want to provide them. And all of this is like you're putting their interest, the client's interest, first. And this is versus the old transactional model where brokers are paid on a markup or a per trade basis. The advisor model also offers the transparency and the flexibility to allow managers to attract and service accounts of all different sizes, which is a great option. But whatever these motivating reasons are, whether it's for more freedom in your lifestyle, choosing investments from a larger universe, providing better service to your clients, or kind of just getting away from the sales-driven model to the advice-driven model, careful planning and strong support will make the transition go smoothly. The primary thing here is you need to set expectations, and the end result will be a practice that you have created. I would like now to introduce Brent and Thomas to start the webinar, and I'm pretty confident this will be extremely informative to any asset manager looking to start and manage their own advisory business.
Thanks, Willie. I appreciate the introduction and the opportunity to present today. So this presentation is geared towards individuals who are interested in setting up an investment advisory business. We're going to move quickly through a variety of topics, but we'll also address your questions during the presentation and afterwards. And if we don't answer all of your questions, feel free to reach out to either me or Tom. We'll provide you with our contact information after this presentation. Tom Hertog is our co-presenter, and we'll introduce him in just a minute. But please do reach out to us if we don't cover all of your questions. And you can submit them, as Cynthia explained, through the chat feature. And be sure to direct the question to either all the participants or all the panelists so everyone can see your question. And we'll also conduct some polls from time to time so that we can better understand the backgrounds and objectives of everybody who's participating today. So with that, I'll just run through what we hope to cover. We've got a lot to cover in a relatively short period of time, so this is really going to be more of a high-level discussion about a variety of topics. So at the outset, we'll discuss the concept of an investment advisor from a definitional and regulatory perspective, and then we'll also compare some of the different types of advisors. And then we'll talk about special considerations for individuals who are currently employed at brokerage firms who are considering breaking away from those firms to set up their own businesses. We'll then consider some of the business issues that startup advisors face, from working out the terms of a partnership with their partners to branding and marketing, as well as other issues that are involved in building an advisory business. And then lastly, we'll move into a general discussion about the registration process and the regulatory and compliance issues that confront most advisors. So before we dig in, I'll just give you a brief overview of our firm. 100% of our practice is focused on the investment management industry. Most of the attorneys at the firm, like myself, used to work at large, nationally recognized law firms where we essentially did the same thing that we do now. We don't have a lot of the overhead and inefficiencies that we used to have at the larger firms, so we typically can provide those same services very cost effectively to smaller emerging managers. We also represent some of the largest funds in the country and some large registered investment advisors, and routinely work with individuals who are breaking away from other investment management organizations. So I've been practicing for over 18 years, almost exclusively in the investment management space, and represent hedge fund operators, registered investment advisory firms, commodity trading advisors, commodity pool operators, both in the U.S. and outside the U.S. And my colleague Tom has been providing compliance-related services to investment management firms for many years, and he'll talk a little bit later in the presentation about some of the compliance-specific obligations that registered investment advisors have to be concerned with, and we'll also give you an overview of the SEC versus state registration requirements and the ongoing compliance obligations that you'll have at either level. He has worked at some of the largest accounting and consulting firms prior to working in the investment management industry, and then routinely helps a lot of our clients respond to SEC or state examinations and with designing and implementing compliance programs. So at the federal level, the definition of an investment advisor, pardon me, let me just, the pointer feature working here. So Section 202 of the Advisors Act defines at the federal level an investment advisor as providing investment advice for compensation. They have to be engaged in the business of providing that advice, and they have to typically make these recommendations by issuing reports, furnishing analysis on securities, or through publications. And it's important to remember that a person or firm has to satisfy all three elements to be regulated. A lot of our clients, prior to launching their businesses, have advised, family members or friends, and weren't actually charging fees for these services. And so they were concerned whether or not they should have been registered. Well, the answer is no, because they weren't providing these services for compensation. It's also important to note that a lot of the states have incorporated exemptions from the registration requirements. So most states' statutes will track this federal definition that we're looking at here at the first bullet point of an investment advisor, but many states will provide exemptions for advisors, even if they're charging fees, who have fewer than a certain number of clients who are residents of the state. And typically, the general limitation is 5. So an advisor who had 5 or fewer clients during a 12-month period would be able to avoid registration, but keep in mind, only in certain states. Most states don't have this kind of exemption, but many do. And so prior to taking the 6th client, the advisor would have to register. And then there's also a national de minimis exemption, which, pursuant to federal law, would prohibit the states from requiring an advisor to register if they have 5 or fewer clients and no place of business in the state. So if you're registered, say, in New York, and you have 3 clients in Florida, Florida cannot require you to register as long as you don't have a place of business. But you also need to keep in mind that that place of business definition is very broadly construed by the regulators. And we've had cases where the regulators required registration even where the advisor was only operating for a few months out of the year from a vacation home. So they felt that, because the advisor was making investment decisions on the soil in Florida, he should have been registered. And so we helped him work through that issue and get registered there in Florida. And then other states will have, pardon me, sorry about that, guys. Other states will have requirements that in order to use the de minimis exemption, there's a prerequisite that the advisor not hold him or herself out to the public as an investment advisor. And that means that no marketing, no business cards, websites, yellow page advertisements can be utilized if you're going to rely on the exemption. So, for example, in Florida, you can actually have up to 15 clients, but you cannot hold yourself out to the public. So it's really a friends and family exemption, whereas New York has an exemption that allows you to have up to 5 residents of New York without registering, and you can hold yourself out to the public. So the key takeaway is that each state has its own set of regulations. There's not uniformity from state to state, so it's really important that you seek counsel prior to launching an investment advisory business if you intend to rely on an exemption. And lastly, certain states don't require registration for advisors whose only clients are institutions. And last year, 12 states adopted their own version of the private fund advisors exemption, which was promulgated pursuant to Dodd-Frank, which enables private fund managers, such as hedge fund managers and commodity pool operators, to avoid registration. They simply have to file as exempt reporting advisors. And in order to utilize this exemption, the investors will generally need to meet certain net worth requirements. In certain states, like California, it's $1 million, excluding the principal value of the individual's residence, so they have to essentially be accredited investors. And in other states, to use the private fund advisors exemption, the clients all have to be qualified. And that's a $2 million net worth requirement or a certain amount of assets under management, $1 million under management with the advisor. So again, if you want to rely on one of these exemptions, it's important that you really understand the framework in the particular state in which you reside. Oh, and then there's one other exemption, that's the publisher's exemption. And so a lot of our clients operate newsletters or other kinds of, stock picking services where they provide advice that's not tailored to the unique needs of any client, and they do this through the website or through print publications. So there is a publisher's exemption. However, it's really important that you understand the limitations, and the SEC in the states sometimes narrowly construe that publication, and we're happy to take specific questions after the call. So I'm going to go ahead and address one question here, and then we're going to do a poll. So the question is, do I have to register if I just publish a newsletter, which in fact are auto-traded by a third-party custodian? Very good question. And in fact, this is really the use of social media, and there are sites like I think it's Ditto Trade and a number of others that provide sort of auto trading capabilities, and a lot of brokerage firms are developing these capabilities. And there was a general sense for a number of years that one did not have to register as an advisor. Our position, and the SEC seems to be taking a similar position, that to the extent that your signals are resulting in an individual's account being auto-traded, that you do need to register as an investment advisor. And the SEC, if you Google sec.gov and the word auto-trade, you'll actually see a release that the SEC issued a couple years ago on this very topic, and that they do take the position that auto-trading would require registration. So with that, Cynthia, if you wouldn't mind, let's go ahead and conduct the first poll just so that we have a better sense of who's on the call and what everyone's interests are. So we're looking to say, who's currently a broker and exploring the possibility of establishing your own RIA? Are you currently a rep of another RIA but interested in setting up your own firm? Third, are you not a broker or investment advisor representative but still interested in setting up an RIA? And lastly, you currently operate an RIA and would like to improve or grow your business. So please take a moment and respond, and then we'll have a better sense as to everyone's backgrounds. And here's another question. Do you offer services to set up a new RIA company, including filing with states where the advisors are providing services? And that was asked, Aaron, we do provide those services. That's actually one of our core competencies here at the firm. We have a division within our firm that provides exclusively registration and compliance services to investment advisors. And one of the benefits of working with our firm, as opposed to, say, a consultant, would be that you'll have attorney-client privilege. Unfortunately, if you're working with consultants, there's no privilege, and so if down the road you found there was a problem and something you wanted to discuss, if you screwed something up, if you put that in an email to a compliance consultant, then that's actually discoverable by the regulators, whereas it would not be, if you work with a law firm. But we do provide startup services, and a lot of our clients are launching as one or two-person shops, and we can provide kind of, I guess, a complete, on a flat fee basis, a complete setup from helping one to select the entity to putting the investment advisor contracts in place and working through all the registration issues, and then afterwards we'll stay on and help with any kind of compliance matters. So let's move on through the presentation to the next slide. If we look at the segmentation of the RIA marketplace, there's really a variety of different types of organizations, and to start with, you have general wealth managers who will provide financial planning to high net worth individuals, including investment management, estate planning, tax management. So they really look holistically at a client's financial situation, put together. Sometimes they do financial planning. Sometimes they really just focus on the asset allocation. So there is a difference between wealth management and financial planning, although in many firms, the wealth management firm will have a financial planner on staff to really try to meet all of the investment needs of a client. And then we have money managers who really just focus on trading and investing their clients' assets. They don't want to provide investment advice that's tailored to the clients. They don't want to do a lot of the hand-holding, and in many cases, the money managers will actually work with third-party investment advisors who are manager of managers, and they don't really interface with the client that often, other than just to trade the account. However, there still are suitability concerns that these managers have to be thinking about. And then we've got the family offices and multifamily offices where the advisor will provide services to very, very wealthy, I like to call them individuals, multi-generational families, typically with $10 million or more in assets. So let's look at the polls. So it looks like most of the advisors, most of everyone on the call here is currently not a broker or an investment advisor, 81%. A few currently do have RIAs, a few are reps of other firms, and we've got a few brokers who are interested in breaking away and setting up their own investment businesses. And I'll take a moment. I'd like Willie just to talk a bit about the interactive platform and how they work with a lot of the wealth management clients and money management clients and the kinds of services that they can provide as a platform for you to operate a business.
Yeah, perfect. And this is one of the few things that is actually pertinent that fits into Brent's presentation. So one of the programs that we have just initiated recently is our Money Managers Marketplace. And basically, this is IB's first electronic forum designed to connect wealth managers and money manager advisors. And the reason this is so compelling is because what we've done is there's certain, the segment would be the wealth manager and the money manager. Now, the wealth managers are professional advisors who really focus on gathering of client assets. And we give them the ability to connect with money managers who have expertise in exclusively trading. And whether that's equities, options, Forex, domestic bonds, or international markets, all products we offer, we allow wealth managers to connect with these money managers on our platform. And the only prerequisite is that you must be registered to participate in this program. And our technology really supports the ability for these wealth managers to add clients, to fund client accounts, to set client fees, and to set client trading permissions. And then on the money manager side, money manager advisors can advertise their trading expertise that opens them up to large pools of potential new clients. And the IB's money managers have access to IB's trading platforms, our execution, and this is across multiple asset classes. And money managers can just open a money manager account, and then they can accept client trading assignments from these wealth managers. And once again, our technology gives them, the money manager, the ability to log into a single screen and trade from multiple client accounts across multiple wealth managers, as well as to allocate trades to a subset of assigned clients for multiple wealth managements. So once again, if you want some more information on this, reach out to me, but this is one of the things we're offering at IB that's really cutting edge. And I'll pass this back to Brent.
Okay, thanks, Willie. And and Tom, if you just want to cue me, I believe Cynthia was going to we had a couple of other polls throughout the presentation. Sure. If you wouldn't mind just cueing me. So in terms of the breakaway broker discussion, we're not going to talk too much about this because we don't have a lot of folks on the call who currently are with wirehouses, but let's talk a little bit for those people who are considering it, and then I'm happy to take more specific questions via call or an email. And as Willie said, there's continues to be a large-scale movement of financial advisors to independent channels, and for obvious reasons, and some not so obvious, but the idea to have more flexibility, more control and autonomy over your business. Just the idea of working for oneself is very attractive, and not having to push proprietary products. So there are a variety of different reasons why I think we see brokers continuing to leave larger firms and setting up their own independent firms. And then there's also the availability of the hybrid RIA BD option. So there are friendly broker-dealers out there that will let you hang your license and continue to collect, say, mutual fund trails while you're building your investment advisory practice, and maybe you still want to sell certain products, variable annuities, and so there are broker dealers that you can affiliate with. So if you do all the trading through IB, we can recommend some broker dealers that will also let you house your Series 7 license or 6 license if you want to still sell load funds, for instance. And then lastly, we see a lot of brokers leaving because, and also individuals leaving larger RIAs because they want to start private investment funds. And that's a big part of our practice. We probably launch 60 to 80 private funds a year across a variety of asset classes, many sort of traditional long-short equity hedge funds, but also individuals that trade Forex and futures and want to launch commodity pools and who will trade a variety of different assets. And so it's often very difficult to get the compliance departments of larger investment organizations to agree to permit their reps to launch private funds just because of liability concerns that often are not really rational, but still it's too much for these larger organizations to swallow. So I think we have another poll we want to undertake, Cynthia, dealing with forming an RIA. and that would be for those of you who want to form an RIA, what kind of firm are you interested in operating? And this really would wealth management firm sort of ties back to the previous slide. A hedge fund, a family office. So while you guys consider that question, we'll move on. And I'll mention a few more considerations for departing brokers. It's really important to look at the contracts that you signed with your firm, non-competes, non-solicits. You want to review all the compensation and benefit agreements carefully and really think about timing issues because it can take months to complete a registration, and so it can be a little challenging to start the paperwork because that could be construed as an outside business activity, although our firm takes the position that simply completing paperwork to the application is not really engaging in business, but the timing issues can be challenging, and then you need to make sure you understand the firm's disassociation protocol so you don't create any situations that might result in liability. So looking at this questionnaire, this last poll, 13% are interested in a wealth management firm that also provides financial planning. It looks like 36% want to provide money management services that don't provide customized and tailored advice. The majority are interested in setting up a private fund or a hedge fund, and a few are interested in family offices. So this is really helpful to know. So we can spend a bit of time talking about what's involved in setting up a hedge fund, as well as what exemptions might apply. So the considerations from a choice of entity standpoint, if you're starting up an RIA firm, are going to be very similar. Whether you're starting a hedge fund or an RIA, you're generally going to establish an entity, and it's important to use an entity because it'll provide greater protection of personal assets. You can separate your personal and business information, financial information if you're ever audited. So if you do everything as a sole proprietor, if the IRS comes in, then your entire business is going to be subject to the audit in addition to your personal information. And there are strategies that can help you reduce taxes, retirement plans that you can put in place. Having an entity will enable you to develop employee stock ownership plans, develop succession planning options, and just really provides more legitimacy in the eyes of prospective clients. So I think we all generally agree that it makes sense, all of my colleagues, to have an entity, whether you're operating an exempt or registered investment advisory firm. And those entities are generally going to take the form of an S Corp or a limited liability company. C Corps generally don't make sense. The S Corp provides a bit more, provides the ability to avoid the Medicare, Medicaid taxes, which are unlimited with respect to partnerships. And this is really an area where a CPA should probably weigh in. I'll say that most of our clients opt to form their registered investment advisory firms or hedge fund management companies as LLCs, simply because of the flexibility that entity affords. You don't have sort of rigid formulas by which the profits need to be allocated to the owners. So generally, myself and most of my colleagues who are attorneys feel that an LLC structure makes the most sense rather than an S Corp. And when you're starting a business, if it's just yourself, well then none of these issues really are going to be relevant. But if you have a partner or more than one partner, then it's really important to think through a lot of the business issues that will address that could impact the firm as it initiates operations and during the course of its operations, from capitalizing the firm, working out the financial and ownership terms. There may be vesting schedules. It's important to really determine what each person's responsibilities will be, how profits and losses will be allocated. Voting rights are certainly an important aspect. If you decide you want to sell the firm one day, does it require, unanimous vote, majority vote? If you want to hire a key employee, what sort of vote might be required? If you want to invest in software or other kinds of infrastructure, these are all important business issues that will require votes if you have more than 2 members. And if you have 2 members, then that are 50-50, then you always have the possibility of deadlock, and we have to work out mechanisms to deal with those sorts of situations. And that may be that we have a buy-sell provision if you can't work out a resolution with a partner who's 50% with you. And then lastly, there's a number of fiduciary duties. If you have employees or partners, you want to consider non-competes. You want to consider duties of loyalty and disclosure. And by duty of disclosure, I'm referring to the requirement that a partner at least have to let his other partners know if he's engaged in some other kind of business. And then there's confidentiality agreements that you may want to have your employees and partners execute. So we don't have time today to go into all the details, but we do have a question. At what level of AUM does it make sense to utilize our services? Really, there's no AUM requirement. We have clients that are launching that have no assets under management and are really just getting started. So we'll be happy to work with very small firms, and we're able to provide cost-effective services to firms that are just starting out that are small. So if you're starting out as with a partner, just to finish up this slide, it's important to consider all of these types of business issues, and then there's a number of others that you'll need to work through. And this presentation wouldn't be complete if we didn't talk about some of the challenges that are inherent in starting an RIA. So this is, it's a great business, I think, for a variety of reasons. It's scalable. You don't need to necessarily add employees to add assets. Unlike my business, I'm being in the professional services industry as well. It's hard to scale the firm unless you add more attorneys, more staff. And one of the great things about the RIA business is that you don't necessarily need to scale up. You could go from 10 million to 100 million and not have to add an employee kind of lockstep with the asset growth. And also RIAs can be sold down the road as well as hedge fund organizations. So you potentially are building equity in a business. So these are some great things about the investment and management business in general. But then the challenges would be time. If you're starting out with just one on your own or with one partner, it's hard to do everything. Client service, business development, compliance, operations, and staffing up is not easy. Finding the right employees at the right time. Marketing has its challenges, and we'll talk a bit about some marketing ideas in some subsequent slides. Capital can be a problem. Having enough money at the outset to do everything you want to do to build a business, whether it's there may be travel expenses, advertising costs. You may want to hire key employees, but you don't have the cash flow at the outset. Maybe you can be creative and offer equity. A lot of my clients who are starting hedge funds who just want to keep their head down and manage money will sometimes give equity away to someone who's more marketing oriented to help with business development responsibilities. And in fact, another one of our clients actually set up a specialty finance firm to help provide financing to registered investment advisory firms that are capital constrained, so that they will provide growth capital. They themselves understand that need, having been in the business of investment management. And then, branding and is important. I think it's worth paying a branding consultant to really help you, get that right. And make sure that whatever brand you choose communicates, credibility and trustworthiness. And lastly, it's really important that you develop the processes as your firm grows and you have more clients to make sure no critical balls are dropped, that all of the, from a compliance standpoint, that all of the compliance obligations are being met at the firm, and that your investors are getting statements, correct statements when they're supposed to get them. So there's a lot of processes that need to be developed and perfected. So there's a lot to do, but the rewards are there for those who are able to, scale the business and over time. When you're launching a firm, there are a number of considerations. You've got to look at legal costs, registration fees, office expenses. Some of our clients launch the businesses out of their homes in the beginning just to keep costs down, software, and so forth. Generally speaking, we're able to set up a small 1- or 2-person RIA for around $5,000, and that would include pretty much everything soup to nuts that you're going to need to get into business, from forming the entity to consulting with you about tax issues that would involve the management company in the case of a hedge fund or a registered investment advisory firm, dealing with all of the compliance, and then we'll generally stay on for 6 months and provide ongoing compliance support after the firm has been set up. And we'll also provide the investment management contract. So we really try to take a holistic approach to helping our clients who are starting RIAs for the first time with all aspects. So there's tax, regulatory, just general business and operational concerns. Some of our clients want to manage RIA assets, so that those require specialized advice from our RIA counsel. So that's just a bit about the costs. And then in terms of the fee structures, we're going to go ahead and issue a poll dealing with fee structures. And there are 3 questions. For those of you who are thinking about starting an RIA, what kind of fee structure would you like to charge as an investment advisor? Percent of assets under management, performance fees, or a flat or hourly rate? So most of you who are interested in starting hedge funds would want to charge a performance fee and a management fee. I'm not sure if you can select both in this poll. So go ahead and, if you want to charge a performance fee, go ahead and select that option if you're not able to select both A and B, even though you might want to do both. So I'll note that for those investment managers who want to charge performance fees, in most states and at the federal level, there are net worth requirements that your clients are going to have to meet. And in most cases, that's a $2 million net worth requirement, excluding the value of the person's principal residence, or the individual can have $1 million under management with your firm. So that's the qualified client requirement that the investors need to meet in order for an investment manager to charge performance fees. But in some states, like New York, there is no restriction on performance fees. And in other states, if you start a hedge fund, you can actually have clients in the fund who may not meet the qualified client standard, but yet who are accredited, who can be assessed performance fees. So because many hedge fund managers are exempt from registration at the state level, they don't necessarily have to follow the qualified client requirements. Although I think it's advisable for the manager to do so. Under state and federal regulations, they would not have to because of the exemption. And we can talk more specifically about those details if you have questions about your particular state. Feel free to send me an email, and I'll be happy to respond. And then some RIAs will charge just hourly rates or flat fee rates for financial planning services. It looks like the majority of almost 60% here, 58% want to charge performance fees. No one wants to charge flat or hourly fees. And then 42% are interested in just charging an asset-based management fee. So that does seem to make sense given that so many of the participants are interested in starting hedge funds. We'll have to save a little time at the end to talk a bit about that process, or maybe we could have a separate webinar on what's involved in starting a hedge fund. So I'm going to speak briefly about some of the marketing concepts And there's one more poll we want to undertake, and I'd like to know if you initially intend to market to retail investors or institutional investors, or both retail and institutional investors. I suspect that most of the participants here are probably going to are initially going to market to retail investors. Even if you want to market to institutional investors, it generally takes at least a couple years, if not a 3-year track record, and a decent amount of assets under management to really even be eligible for consideration by most institutional investors. And that's certainly a great place to be, but it takes time to build the business to the level that you can be considered by institutions. So in terms of the overall marketing plan, it's important that you really think through, who your target audience is going to be. It looks like just a very small percentage are institutional investors. Looking at the poll results, 56% will market to retail, 39% to both retail and institutional. So that's in line with what I was thinking. So as you start to develop the firm, it's very important that you develop a marketing plan and really think through who your target client market is going to be and also how you're going to reach them. I'll say that with the Jobs Act, it's now possible for private fund operators, hedge fund operators, to mass market to accredited investors, whereas they were not able to do this previously. And we're going to deter a little bit from the general presentation just because so many of you are interested in starting private funds. Generally speaking, from a marketing perspective, under the old regulatory regime, you were not allowed to use any kind of general advertising or solicitation when you wanted to raise money for a hedge fund. Under Regulation D, which is the exemption you would use to market a private fund, you were restricted to marketing to individuals with whom you had a pre-existing relationship. About a month ago, the laws changed. That under the Jobs Act, there was a mandate that Congress and that the SEC revise its rules to permit mass marketing by issuers that are using Regulation D. And so as long as you're only marketing to accredited investors, you're now able to use general solicitation advertising to market your fund if you have a hedge fund. And the primary, I guess, caveat is that if you opt to mass market, then you have to undertake an extra level of due diligence to determine that the investors are indeed accredited. Under the old regime, which you can still use, there's an option to use either the mass marketing approach or the approach where you're only dealing with individuals or marketing to individuals with whom you have a pre-existing relationship. If you opt for the new regime where you can mass market, then you have to undertake an additional level of due diligence to determine that someone's accredited, which could mean looking at tax returns, getting a verification from the individual's accountant or attorney, and there's a few other safe harbors that the SEC has stated would suffice. Under the old regime, all the investor has to do is check a box. And as long as you have a bona fide, reasonable belief that they're accredited, you don't have to undertake any additional due diligence. So that's a very sort of groundbreaking change, and I think we'll see a lot of private fund managers starting to mass market, at least those who are willing to jump through the additional due diligence hoops of verifying their investors' net worths.
Yeah, Brent, can I just speak to that very quickly, the Jobs Act? So from the custodial point of view, this is, like Brent said, this is a really, really breakthrough law for emerging managers. And along the lines is, once they have ascertained or really defined the rules to what you need to do once the investors come in, that will be determined very shortly. And I think this thing comes live actually next week. So there'll be a lot of information out according to what you need to do to vet potential investors. But at the very least, you'll be able to go out and you'll be able to advertise, whether that's through a website or any way that you can kind of get your message out there. You're allowed to do. And that has changed the game completely for emerging managers, because now you can go to high net investors and even people that you don't have to take the time to determine who's qualified and who isn't on the initial blast or going out to represent yourself. So really keep your eye on this Jobs Act. And once again, Brent has really been involved in this Jobs Act and how it's progressed through the SEC. So I would reach out to him, also along the lines as what the Jobs Act is going to mean to your business. So I just wanted to be sure you guys were really aware of this act. It's a very important breakthrough for emerging managers.
Okay, and I'm going to take, thanks, Willie, and I'm going to take a quick minute to answer some of the questions that have been asked. So here, there's a question about just the cost and ongoing cost for setting up an RIA or a hedge fund. And so we spoke briefly about the cost to set up an RIA, and I mentioned that we could do that for as little as $5,000. Plus the cost associated with state filing fees, and then your ongoing compliance costs might be a couple $1,000s a year if you're a small shop. It's not going to be too burdensome. And I'm assuming a one, maybe two-person shop. The startup costs are going to be a bit more if you have more than just a few people, and the operating agreement, the work to develop an operating agreement would be more involved. So that general price point will go up as the complexity of the project, depending on the complexity of the project. And then in terms of setting up a hedge fund, I say somewhere between $15,000 and $20,000. Really, that cost is going to be driven by in which state the manager is going to reside, what registration requirements might need to be undertaken. So if you live in, say, New York, for instance, where you don't have to register as an investment advisor, or in Florida or Georgia, or I'll go ahead and name some other states, Pennsylvania, Ohio, North Carolina, now Connecticut, and there's a lot of other states that have exemptions from registration that you can rely upon, and the legal costs are going to be a bit less if you don't have to go through the registration process. So that certainly is a consideration, and in that point we can typically set up very basic funds for around $15,000, and that, in the spirit of our engagement, would be to provide you with all of the services that you're going to need to launch. So obviously that would be developing a private placement memorandum and a partnership agreement, and the subscription booklets that investors have to sign to purchase interest in the fund, and then the tax and ERISA advice, helping you making the filings that need to be made with the SEC and the states where you're raising money. So again, the spirit of our engagement would be to provide for a fixed fee everything from start to finish that's involved in forming a hedge fund. And if you send me an email after this call, and I'll go ahead and give you my email address now, and I'll give you my contact information again after the webinar. But you can email me to bgillette@investmentlawgroup.com, and that's BGILLETT @investmentlawgroup.com. I'll send you some information about starting a fund. I don't want to go off too much on this topic because it's not the focus of today's webinar, but because so many of you are interested, I wanted to at least give you some basic information and address some of the questions. So as we continue to move through, as you're developing a marketing plan, I can't emphasize enough how important it is to really brand the firm. And as we've seen, successful businesses generally have strong brands, and to create a strong brand, you really need to identify the qualities that you want people to associate with your firm, which would include how you want potential clients to perceive your business relative to the competition. And then you want to make sure that everything about your business reinforces the brand, from the letterhead to the website. You may want to have a blog or a newsletter. And then secondly, if you have a website, one, you should make sure that it's reviewed by counsel, especially if you're marketing a private fund, to ensure that it's compliant, and be very careful with posting, performance data from even a proprietary account, because there's a lot of areas where you can trip up from a compliance perspective if you don't have the right disclosures. And another no-no, for instance, on a website is posting past specific recommendations. So many of our clients aren't aware, both hedge fund managers and just registered investment advisors who have general wealth management businesses often want to tout, the stocks that they recently picked or, picked a while ago that really worked out well. And unfortunately, the SEC sees that as cherry picking, and there is a way to do it, but it requires adherence to very specific procedures. So that's a really common compliance mistake that many clients make when they're trying to market their services and using performance data to do so. And thirdly, another way to market your firm is to begin blogging. There's several clients who were published on Seeking Alpha, for instance, and they were discovered by some very high net worth investors who really liked what they wrote, and it worked out pretty well for the clients. They picked up several $1 million of assets. The downside is that creating good content is going to take a lot of time and effort. So nothing's easy, but we've seen over and over that this strategy has worked for our clients, and it's a very legitimate way to sort of get yourself out there. And then there's social media, and so the use of social media by financial services industry participants is really accelerating. The SEC itself has stated that social media is landscape shifting. It converts traditional two-party advisor to client communication into an interactive multi-party dialogue among advisors, clients, prospects within an open architecture accessible to third-party observers. So the SEC is taking a very close look at the use of social media, and it's important that if you do use social media, or if reps of your firm use the social media, you really need to get compliance advice to ensure that you're keeping proper records, because interactions on Twitter are records that need to be kept under most state and certainly the federal rules. So if you're going to use social media, it's a great tool to enhance your business relationships with existing clients and can really help you reach a targeted audience. But there are a lot of compliance obligations that go along with this use. And another way you might want to market yourself is to underwrite events in the community. You can speak at local trade associations. You could publish an e-newsletter. I have clients who publish newsletters, some who charge a fee for the service, others who don't, and it's a great way to sort of build a brand around your firm. And lastly, conduct webinars like we're doing today on subjects that might be of interest to potential clients or investors. So let's keep moving. With that, I'll let Tom talk a bit about the state versus SEC registration requirements, and then I'm going to take a look at everyone's questions while he's talking, so we'll try to get through a lot of the questions after the call. So, Tom?
Excuse me. Thank you, Brent. As we've been discussing throughout the entire webinar this morning and now into the afternoon, there are some threshold levels that we need to be aware of when we're talking about registration. So there's registration with your state and or states that you exceed the de minimis requirements for the number of clients in, generally in the neighborhood of 4 to 5 clients in those states. And then there's registration that's required when you reach a certain threshold in terms of assets under management. And the magic number for SEC registration is $100 million. Now, there are some exceptions to that, whereby if you have separately managed accounts and funds under management, you would need to register at less than $100 million. But generally speaking, when you reach $100 million and no higher than $110 million, you absolutely have to register with the SEC. State registration continues to be, for those firms, generally speaking, with 5 or more clients, or more than 5 clients, up to $100 million in assets. So as you're considering your business, and as we know from the previous polls, a large percentage of you aren't presently engaged in this business. as a broker, dealer, working at a wirehouse, or as an investment advisor. But for those of you that are in the business, in the industry, and you're thinking about breaking away from your current wirehouse, broker, dealer, or advisor, think about the size of the book that you may be transitioning. And if the size of the book you're going to be transitioning is going to potentially exceed, if you're able to successfully transfer those clients, $100 million, then you should plan on registering with the SEC literally day one. There are some situations in which advisors who are breaking away or even financial planners who heretofore had not been managing money but developing plans for their clients and now want to manage a book are breaking away from that business. Most likely they would want to register with their state in anticipation of meeting or exceeding the de minimis requirement for the number of clients in that state or states that they have clients in, all the way up to the $100 million point. So as we move forward and focus now on state level, there are some exceptions. As we've said before, if you have less than 5 clients in a state, you don't need to register. If you advise on a private fund, that is an exemption in some states. If you have a place of business in a state, such as a branch office, maybe you hire a rep in a neighboring state, you do need to, generally speaking, you do need to register with that state as well, not just the state that you have your home office in. One thing that's really happened quite dramatically in the last several years as the SEC raised the threshold for registration to $100 million is that state regulators are now focusing very, very closely on initial registration forms. And that form document is called Form ADV, which is just short for advisor. So you need to be very careful when you're forming your entity, when you're filing your initial registration documents, Form ADV, with your state or states, if you're filing in more than one state, that you do it correctly. And that's one of the real core competencies that our firm has is in helping advisors and broker dealers or brokers breaking away to file the right forms with the right states. One reason for being careful about this is a lot of states will conduct an examination of your RIA firm within that first year being registered. So it's very important to get your documentation right to avoid a deficiency letter. And then lastly, making sure that you're filing the correct U4 form in the correct states in which you have a presence in office and or notice filing in those states in which you have, generally speaking, 5 or more clients. Again, at the state level, you do need to register any individual who's employed by an investment advisor. Essentially, anyone making recommendations, anyone giving investment advice, anyone who's managing an account, managing a portfolio, giving recommendations or advice as to which securities you're recommending to be bought or sold on behalf of a client.
And I will say, just a note, Tom, that we're asked a lot of times by individuals who operate hedge funds, can I pay finder's fees or referral fees? And generally the answer is no, unless they're licensed with a broker-dealer, not just registered as a rep of the RIA, because interest in a fund are securities. So limited partnership interest, LLC interest are securities. And so if an individual is helping to raise money for a fund, for example, that individual is engaged in selling securities, and any kind of remuneration would be deemed to be a commission by the regulators. So that gets a little complicated, and there are things that, ways to sort of make individuals employees, but they really have to have substantial duties other than raising money, and that's really a separate conversation. But that's just one thing to keep in mind. And then there's the concept of solicitors, and a few states do permit unlicensed solicitors to raise money for managed accounts for registered investment advisors. But most states are going to require the solicitor to actually register as a rep of your firm in order to refer clients and be paid, or they'll have to set up their own RIA. So With that, sorry to interrupt.
That's an excellent point, because as you're starting your business, and perhaps you have, perhaps it's just yourself, perhaps one or two other individuals, obviously it's imperative that you attract assets. And oftentimes you may know of other professionals, non-competing professionals such as CPAs, attorneys, insurance agents, financial planners, who want to pass along their clients to you. But as Brent just pointed out, you do need to determine whether or not they need to be licensed. And you certainly need to have legal counsel, such as our firm, help you draft a solicitor's agreement or referral agreement, because that is required, that you have in place a written document to document that relationship. Moving forward now with the ADV. Again, the ADV will be filed with both state and federal, SEC, regardless of whether or not you're at that $100 million threshold or not. And very high level, without getting into the details here, what we're looking at is you need to state what the qualifications are for the principals, fingerprint cards, background check. You'll need to create and draft a compliance manual, code of ethics, and what's called the DRP, or disclosure reporting page, which talks about any disciplinary action that you or any associated person in your firm has been a part of, whether it's FINRA or whether it's SEC. You need a privacy policy, advertising and promotional materials you need to think through, especially those that have performance information. And lastly, your books and records. Books and records are a very, very important element of any compliance program. Under Rule 204 of the Investment Advisors Act, it actually is responsible for generating the highest number of deficiencies in exams. So moving to the next slide here, preparing Form ADV, some very basic things as you might think, firm information, address, principals, hours of operation, your website. The legal form, as Brent talked about earlier, whether it's a sole proprietorship, corporation, partnership. Generally, at a general level, talking about the types of investments being made, any conflicts of interest that you have. Custody is a real big issue. Are you going to have custody? Are you going to bill your clients in such a way that it creates custody? Who are the control persons? Officers, directors, direct owners, indirect owners. And again, lastly, disclosure reporting, any disciplinary action. Preparing Form ADV is something that, frankly, we don't recommend that you do on your own. You should seek counsel. Obviously, we're a great firm at providing assistance with forming your ADV. But for any one of you that have actually read an ADV in contemplation of starting your own firm, it is a serious endeavor. And we've just listed here on this slide, number 24, a few of the data elements that are required. You'll be able to download this presentation after today's webinar, so feel free to look at slide 24 in more detail. But it's quite a serious endeavor. One of the misconceptions regarding filing ADVs, whether it's with the state or whether it's with the SEC, is that it's largely check the box, it's boilerplate. It's really not. Maybe 10 years ago it was, but it's not. The SEC actually reads ADVs now. The states have always read them, and frankly, they have a mandate to issue deficiency letters to make sure that they're screening out advisors who frankly shouldn't be registered in the states. So you see here on slide 25, again, some high-level issues. Not providing all the required documentation will get a deficiency. If you don't provide how fees are calculated, that will result in a deficiency. You're not allowed to use acronyms RIA, which we all understand to mean Registered Investment Advisor, or IAR, Investment Advisor Representative. States don't like that. And then you get into very specific, state-specific issues regarding language for custody, performance fees. Again, our firm can help you to navigate that successfully and avoid getting a deficiency letter, which frankly is going to delay your time to registration and delay your time to attract assets. Going forward, after you've submitted your initial registration document, you're required on an annual basis to update the ADV. And frankly, what you're looking to do what the state and SEC are looking for you to do is to provide any material changes. Have you moved? Have you changed your investment strategy? Have you changed custody? Have you changed your fees? One of the other things they want you to update at least once a year is the number of clients you have, whether they're discretionary or non-discretionary, as well as the assets under management. You're required to file that by March 31st each year. And if you're SEC registered, that is, you have $100 million more of assets under management, you're required that this Chief Compliance Officer must be designated in your ADV form, and they must complete the annual certification, which you see here as the third bullet point. So you must conduct that annual review. Some states are moving in that direction, so you would need to check with individual states. Going to our next slide, slide 27, this is a high-level look at the registration timeline for both SEC and for state. As you can see, we've got 6 silos here, from establishing your entity in week 1 all the way up to launching the firm in the 6th silo. That time can range anywhere from 45 days with the SEC to several months with states. We've been helping clients register in the state of California, and they have really tightened the screws in the last, probably the past 6 months, where you might encounter a 3-month process to get registered in the state of California. Other states are able to handle that more quickly, and again, we can help you to successfully navigate that.
And part of the key is to make sure that, as Tom said, that the Form ADVs, the states have very specific language, specific disclosures in the investment management agreement that they do want to see, and certain things they don't want to see. And so, unfortunately, if you haven't been through the process, you'll find that there's going to be a lot of back and forth, and you'll get a lot of deficiency letters throughout the registration process, and it can just take a lot of time if you're not working, with a consultant or an attorney that has been through the process a lot. And I realize it's about 10 after 1, so we'll try to wrap up so we can address some of these questions. And probably what we'll do is we'll save this last part of the presentation that deals with preparing for an SEC and state examination. There's this in and of itself, we could probably spend 30 minutes. But because so many of you are currently not registered as advisors, what we'll do is maybe have a separate webinar on this topic for firms that really want to understand how to best prepare for both routine cause and sweep examinations that the state regulators and the SEC are undertaking. And so there's quite a bit more audits going on both at the state and federal level, so it's important to be prepared. And with that, I'd like to ask, there's a final poll where we'll just I'm curious to know how many of you are concerned about compliance. Do you feel that the time and cost of dealing with compliance might create a barrier to entry? Are you concerned about compliance but feel that you can handle the obligations with assistance from an outside consultant or lawyer? Or you're not too worried about it and feel that you can handle everything without too much of a headache? So just curious to see what everyone's perspective is on that topic. And just to finish the compliance portion of our discussion, I'll let Tom talk for a bit about this last slide.
Sure, and thank you, Brent. As you can probably tell from the webinar today, this is a process. There really is not a one-time destination here. You don't get compliant once, achieve that level of compliance, and walk away from it. You need to make sure that your compliance program is in place on day 1, that you begin to foster and instill a culture of compliance throughout the organization, that the principals in the firm set, what they call, the SEC likes to call the tone at the top, which is that compliance, is important to the firm to maintaining certain safeguards and integrity for the benefit of the clients. So keep in mind that, getting registered and opening your doors for business is really just the first step from a compliance standpoint, and that going forward, whether it's filing your quarterly reports, 13Fs, whether it's filing your annual ADV updates, Again, compliance is an ongoing process, not a one-time destination.
Thanks, Tom. And I'll say, just from this poll, it looks like, say, 20 out of 46 participants who participated are concerned about the time and cost of dealing with compliance and are concerned it might be a barrier to entry. 23 out of 46 who responded are concerned about it but feel like an outside consultant can help, and then 3 of you were not concerned too much about it at all. And so I'll address those of you who are really concerned and say that for small shops, if you're a 1-, 2-, 3-person shop getting started, there's not nearly as much compliance overhead as if you're an SEC registered advisor. The audits aren't going to take as long, and it's with the right setup on the front end, you really can get all your compliance procedures in place. We have customized compliance calendars and checklists, and can equip you with all the compliance infrastructure that you need to be totally compliant. So if and when the regulators come knocking, you'll have all your books and records in order. There's software systems, and it's beyond the scope of the discussion to go into detail about specific systems, but there's software that you can get, and we also have a recommended compliance file system that we can provide you with. So you'll have your house in order from a compliance perspective. So with that, I'm going to address just a few of these questions, and then there's a number of questions that unfortunately we're not going to be able to get to, and some that I thought were just too specific. So please feel free to reach out to me after the presentation. I'd be happy to talk with you on a call or via email. Here's one question about what licenses are required to operate an investment advisory firm. You would need a Series 65 license, or if you already have a 7, you'll need a 65 and a 6 to operate as an investment advisor. And that test, it's not super challenging, but there's a lot of information there that you have to memorize, and it's going to probably take 30 or 40 hours of studying. And there are good study guides out there that you'll definitely want to work through. So the Series 65 exam is required for anyone who is involved in soliciting clients or who's actually making the investment decisions for client accounts. And keep in mind, if you're trading futures or foreign currencies, an entirely different regime will apply. And you would not need to register as an investment advisor, assuming you're just trading futures or foreign currencies. You need to register as a commodity trading advisor or commodity pool operator, and we'll probably have a separate discussion or webinar about that, but you don't need to register as an investment advisor. So sometimes there's some confusion by people as to what licensing they need, and you would need a Series 3 to trade futures and a 34 to trade foreign currencies, and that's an entirely separate registration. And a lot of you are asking if the presentation will be available. It will be available on IB's website after the call for download. And here's some other questions. What does it cost to start a mutual fund? The cost to start a mutual fund, generally probably on the low end, $50,000 in legal, but it's the ongoing cost and compliance that's going to really be involved. And it generally probably does not make sense to start a mutual fund unless you can launch with at least probably $20 million, $25 million, and that's on the low end. Some people will tell you you need a lot more in assets, but we've helped small fund managers launch on sort of a bootstrap basis. There's a lot of questions about performance fees, and can you charge performance fees for managing IRA accounts, and the answer is yes. You can charge performance fees as long as the investor meets the qualified client requirements, if that's a requirement in your state. And it looks like there's some questions about trading friends and family's assets and whether or not you're allowed to share in the profits. And performance fee is a type of compensation. So even if you're just trading friends or family, and you're, say, in Texas, for instance, and there's a lot of other states that don't have de minimis exemptions, you need to register as an investment advisor. There's actually a no-action letter that the Texas Commission considered where someone was managing money for his mother-in-law for a fee, and the state said he had to register. So that's just the rule. So there's a lot of other questions that unfortunately we're not going to be able to get to because of the time constraints, and a lot of these questions are very specific, but feel free again to reach out to me. I will go ahead and put the last slide, which has our contact information here. So feel free to email me or just give me a call if there's anything else that you'd like to discuss that we didn't cover. And I just want to thank everybody for participating today, and Cynthia and Willie, thanks so much for having us. We really appreciate the opportunity to have been able to make this presentation.
Yes, and I would like to thank Brent and Thomas for giving this presentation. It was really valuable. And also, there's going to be a PDF about Interactive Brokers, our whole advisor offering that you can review, and if you have any questions, reach out to me. Separately, both presentations will be on the website, and you can also watch the webinar again. So feel free to contact Brent or myself with any questions, and we look forward to having you guys at the next presentation.
I'd like to remind all participants that we have been recording today's event, and you'll get a direct link to today's recorded playback. By the way, as you exit today's session, you'll also find a separate browser window will open up with a PDF copy of today's slides, so you can feel free to either print or save that PDF form directly from our drop-off browser. So thanks, everyone. This is going to conclude our event today. We do appreciate your interest. Have a great day, all, and please remember to trade smart. Thanks, everyone.